what is the process for challenging an administrative agency's action? Individuals can use the Article 3 judiciary to challenge administrative action. That is, individuals can sue the administrative agency or the executive in charge of the administrative agency for its rulemaking action. Now, generally, the judiciary will not review the actual substance of the law as much as reviewing the authority and procedure used to create it. Now, they will not adjudicate the wisdom of the regulation itself. It's more the procedural aspects and whether the delegation to the administrative agency is authorized and constitutional, and if there are any examples of a regulation that goes beyond the purpose or intent of the underlying legislation, then again, it could exceed that authority and be unconstitutional. So generally what the court will look for is a definiteness in the authorization of the agency. So the enabling statute or the delegation of authority from Congress has to be definite and specific. It outlines the specific authority of the administrative agency and what they have the power to do. Next, that authority has to be in some way limited. There has to be at least a reference to limitations or checks on the ability of the agency with regard to the rules it makes, that it stays within the confines of the intent behind the statute. And then if Congress delegates authority for rulemaking and the court finds that the administrative agency went beyond the authority vested to the administrative agency, or that they were arbitrary in their actions and that there is no check on the authority of the agency in the rulemaking process, that there are not specific limitations in place or at least reference to limitations or procedure for checking those limitations, then the designation of that authority could be found unconstitutional. So again, looking for definiteness and limits on the action and authority of the administrative agency.